Hi there, lads. Welcome everybody to this week's SNAP webinar. Thank you everyone who has joined us, and for those of you who haven't met me yet, virtually or in person, my name is Jade and I'm one of the recruiters here at SNAP, and I'm joined by my colleague Jackie and Janet. We are delighted to have Sophie Toft and Rebecca Cherry from Irwin Mitchell present the second part of the life of the claim to help us understand the complexities of each stage of the litigation process. And we are also delighted to have a parent, Tom, who is currently going through the litigation process with his daughter's claim. So I'm going to pass over now to Sophie, who is going to start the webinar.
There we go, take myself off mute. That's a helpful start. Okay, thanks so much for joining us today. Jade, are we moving slides?
Oh.
Jade, I'm sorry. Oh, there we go. Right. Apologies. It wouldn't be a webinar if there wasn't a technical issue to just get us started. Okay, look, as I say, thank you so much for joining us. We're really pleased to be able to come along today. This webinar today follows on from one that was done last month by my colleagues Lauren Herney and Sarah Griggs, who are both partners in Irwin Mitchell's London office in the serious injury and medical negligence teams. They were also joined by a client of Lauren's, Sam, and Kate Coriel, who's a case manager. And the purpose of that talk was really to go through kind of the fundamental bits and bobs around bringing a claim, what the law is around bringing a claim, whether that is something that you might want to do, choosing a solicitor, and then really fundamentally talking about, you know, the significant benefit of bringing a personal injury claim, which is around getting help and support in place. The case manager and Kate and Sam talked about, you know, the practicalities of that. So I've included a link on this slide just in case that's of interest to you and you want to go back. So what Becky and I are going to do today is very much follow on from that previous talk, and we're going to talk a little bit more, I suppose, about the nitty-gritty of the life of a PI claim for a child, so that you've got a bit of an understanding about how these things unfold and the kind of work that goes on with the help of a claimant and their family, and also in the background. And I think that might be interesting or of use if you're considering bringing a personal injury claim, or you're involved with one on behalf of a child or another family member, or indeed perhaps your case manager or an OT or someone else who is involved in the process but on the periphery. Okay, so let's get started. And the first thing I think that's worth talking about is the litigation friend. And the reason we start there is really that it's often, choosing the litigation friend is often the first major decision that's made in a claim. So when you're bringing a claim on behalf of a child, someone under the age of 18 who lacks capacity to make decisions on their own behalf in relation to litigation, or alternatively, you're bringing a claim for an adult who, by way of disability or injury, it lacks capacity to make decisions, well, the law tells us that we must have a formally appointed decision maker who takes responsibility for moving things along. So a litigation friend can be anyone. The requirement is that that individual can fairly and competently make decisions on behalf of the child, and they must have no interests which are adverse to the child. And so on issue of proceedings in a case, so that's when we take a case to court in due course, the litigation friend would be required to submit a certificate to the court, effectively signing off that they can fulfill those two requirements. So as I say, a litigation friend for a child, it can be a parent, but need not necessarily be a parent. It can be a guardian. There are also circumstances in where a parent or a guardian isn't appropriate to act or can't act for one reason or another. Perhaps they were involved in the accident and it wouldn't be appropriate, or perhaps they just aren't in a position to do so. In those cases, sometimes we see godparents or other family members, siblings who are over the age of 18, for example, can step in In some rare cases, and it doesn't happen very often, but where there absolutely isn't someone close to the child who's able to act, we go to the official solicitor, and they act as a litigation friend of last resort. And that really is if there's simply nobody else around. I think everyone would prefer that someone who's personally close to the child takes over that decision making. I think just as a final point on this, it's worth adding in that while there is a single formal decision maker in a case, and making decisions around the structure of the case and settlement and when evidence is disclosed and that type of thing, I mean, that the decisions that need to be made in a case often have far-reaching consequences for the life of a child into adulthood. And so it's really common that we don't just speak with the decision maker, with the litigation friend, but we canvass the opinion and speak with the whole family, and we involve the whole family, and sometimes also the child, particularly if they're older, in those decisions. Okay, so we'll go on to next slide. Here we go. Okay, so we've gone too far. We're having some difficulties. Right. Well, look, I'm going to talk about liability, although my slide isn't quite there. Jade, I don't know whether you can go back to that slide on liability for me, please.
Yeah.
So once we've got a formal decision maker, what we want to be talking about is whether or not there's going to be a successful claim, and we call that liability, but really what we're talking about is responsibility for the claim. So in the UK, it comes as no surprise to anyone that we have a fault-based system. And so in order to bring a claim, you have to show that the child has sustained an injury, which is as a result, which is as a result of the negligence of another. So really commonly in the types of cases that I run, so I do personal injury work, so I will often be looking at, for example, a road traffic accident. And so we're talking about potentially a negligent driver who's caused an injury to a child. In the type of cases that Becky runs, we're talking much more a child's been in hospital and has received medical treatment, and that has caused them harm. So in terms of proving liability, really what we're proving is two basic things: what actually happened, and there'll be lots of big questions around what actually happened factually, and then also what should have happened. And that is often the remit of an expert, whether that be a collision expert in a road traffic accident or a medical expert in a clinical negligence action. There's often lots of witness evidence as well to be gathered, so evidence of fact around precisely what happened and where things went wrong. And that process can take either a short period of time, or it can take a very long period of time. Sometimes with some of the cases that I run, it's absolutely obvious. You've got a drunk driver, they've careened onto a pavement, they've struck someone. Well, there are very few questions to be raised there. Alternatively, sometimes we have people who step into the road, they've got no memory of their accident, there are no witnesses, there might be very limited physical evidence, in which case it's a big old job for us to start piecing together the puzzle pieces to try to work out what's happened and whether anyone was at fault and to what extent. Similarly, in the kind of cases that Becky runs, medical negligence cases are commenting on those is not really for lay people. It is for doctors to take a view on what's gone wrong, if anything has gone wrong, and it can take quite some time to get all of that together. It's a complex and large piece of work. I think the final thing just to be aware of on liability, and I haven't put it on the slide, but it's just around contributory negligence. And so that's where the reality is that we're often looking at a circumstance where an accident is not entirely straightforward. Yes, it's been caused by someone who's been negligent, for example, a driver who's made a bad decision or was driving poorly, but the claimant, whether that be a child or an adult, has also been to blame to some extent. So that might might, for example, be a pedestrian that steps into the road against a red light, but the driver is speeding. In those cases, we look to split liability. So we start to take a view led by the facts and also by the law as to who is to blame and how much. And we might be looking at, for example, that the parties are 50-50 to blame, or maybe the driver takes 75% of the blame and the claimant 25%. And the effect on the claim in those circumstances is that the award is reduced by, say, the 50% of blame that the claimant accepts. Okay, right.
Next
I think
slide.
we'll come on to it. There we go. Good. Right. So in the background, while that's going on, and sometimes a little bit further along the line, we a really significant piece of work that we're involved with, and I think often the most rewarding work that we're involved with in these cases, is really putting together packages of rehabilitation and support. So there is what is known as the Rehabilitation Code for personal injury cases, where claimant lawyers and defendant insurance companies have signed up to say, well, it's only too right that when we're arguing liability, if a child requires support by way of rehabilitation or care in the community, and funds are required, well, even though we haven't settled liability, a defendant should start making payments for those. That is a good way forward and a good way to start things moving in terms of supporting a family, but looking more long term. The way that we normally put things together for families is via interim payments. And what that really means is that once liability is settled in a case, so we know we're going to win, there's going to be a payment of compensation, and we can start to understand the approximate size of that compensation. We can start to have a think about as well getting early payments from the compensation. So that's really payments on account. And that money can be used to fund your child has come into the community, so they might well need physiotherapy, occupational therapy, speech and language therapy, all that type of thing. There might be equipment, a prosthesis or a wheelchair that's required. You may well need a care package, a support worker to get a child to school, or all of that type of thing. It all costs a lot of money, and it's a lot of work. And we put all of that in place, usually through the services of a case manager, who's an OT or a physio or a nurse who's experienced in managing these types of packages in the context of a family, and in a context that works for the individual family and the individual child. And I think if you've got some questions around that, Kate and Sam, who's Lauren's client, talked really interestingly about that in practice. So I'd recommend that you go back to the previous talk, which was done by Sarah and Lauren. Okay. So we go to the next part, which is, so we've settled liability, we've got a care package in place. So a very large part of the case, which often takes us a number of years, particularly with children, is starting to work out what somebody is entitled to by way of compensation. And that's all structured around the principle of compensation, which is that the child is entitled to be put back in the position they would have been in had their accident not occurred. And again, that's basically three things that we need to prove. We need to work out what a child's needs are as a result of the accident and their injury. We need to work out what a child's life would have looked like had the accident not occurred. And finally, we need to work out how we bridge the gap between those two. What can we do with money to best replicate the life that they would have had the accident not occurred, taking into consideration their current needs. And that very much means, working out, would they have worked? What would they have done? Would they have lived independently? And then what kind of money are we going to need to put in place the structures that allows us to live as independent and full a life as possible? Okay, and the reason I say that is that, I think, going on to the next slide, but I've given some examples here, and I think Becky's going to talk about it all in a lot more detail, but some of the things that we might be looking to prove. So currently, with a child, you might be looking at a care package, support worker, case management, rehab, treatment, equipment, so on and so forth. Much more broadly, however, we're likely to be looking at their prospects around work in the future, their care needs. Life expectancy is unfortunately something that we need to keep an eye on. It is morbid and it's a difficult question, but when we're looking many years into the future, we have to know how long are we going to need to support somebody for, and all of that is to an extent crystal ball gazing. So we put together these cases through 3 types of evidence. Basically, there's 3 types of evidence that come together to prove our case under the principle of compensation. And the first is our expert evidence. And I think often is seen to be the core evidence in the case, and there's an enormous amount of it. We have 2 basic types of expert evidence in the case. We often start with medical evidence. So say in the case of a child with a neurological injury, you would want your neurology evidence, neuropsychiatry, neuropsychology, so on and so forth, lots and lots of doctors. And what those doctors will be doing is commenting on diagnosing the injury that we've got, and making recommendations for treating that injury, but absolutely centrally giving us a prognosis as to what the future is likely to look like, and therefore needs into the future. Similarly, sometimes a little bit further down the line, we talk about non-medical experts, and those expert reports will feed on to from the expert reports, and they'll be, for example, an accommodation expert or a speech and language therapy expert. So that's really about somebody who's very well acquainted with that field, translating an understanding of, for example, a brain injury into, well, what does that mean, for example, in terms of housing needs throughout somebody's life. In terms of expert evidence, so I think it's worth saying, particularly with children, they grow older, their developmental needs change, an injury can change in the context of their development, and so it's really common that we obtain a series of reports through a lifetime. It's also important, I think, to understand that there's very clearly a difference between treating doctors who are involved with the child and the medical experts that we're instructing in respect of the case. And the reason for that is this. So when you have a treating doctor who's seeing your child in hospital, well, they have a duty of care to that child to try to make them better and manage their symptoms and concerns. With our medical experts, it's a very different duty entirely. So they've got an objective duty to the court to provide the best, from the best of their experience and knowledge and understanding of what the future is going to look like. And I suppose there is a possible, or there's a potential for those 2 duties to clash, and so the 2 never mix. We never use treating doctors to try to comment on the future for our cases, and similarly we don't use experts to get involved with treatments. The final point I wanted to cover around experts is just what to expect from an expert visit. In the case of a child, that most commonly an expert will come and see you at home unless a visit has to be done in clinic. And with the child, again, you'll always have a parent or a guardian or some other adult to supervise. It's really common that these appointments take a couple of hours. There's quite a lot of information for the experts to glean about what's happened in the past and how a child is doing. And there may also be a clinical assessment. And all of that should be done off the back of a really good assessment by the doctors of all of the medical records and that type of thing. And that should be done before they come and see you, but it isn't always the case. Okay. So we're going to go to our second type of evidence, and so that's witness evidence, and really I think to a large extent just as key as expert evidence is in these cases. So in addition to, well, we were talking about the principle of compensation, and there's a large extent to which that is really individualized from one family to another. No case involving the same injury is the same from one family to another. And the way that we ensure that the structure of a settlement for a client really does reflect the individual child and family that we're talking about is through witness evidence and backing up everything that's in the expert reports from factual accounts from people who are involved. So we take accounts from family members, case managers, therapists and carers, and really that's all about, you know, what was the child like before this happened to them, what are they like now, what is difficult now, and really often they're very long accounts of day-to-day issues. I think witness statements can be difficult to give, and I think a good lawyer will support you to provide a witness statement. It can be traumatizing, I think, to go through, particularly if you're talking about an accident to a child, and you know, everyone's life has changed fundamentally, going through all of that. And I think there's it's absolutely right that that will take time, and you're provided with support to go through that. Okay, I'm going to come on to my last slide, and that's just about documentary evidence, and really it's the last piece of the puzzle when we're looking at putting all of these cases together. And so in addition to our medical evidence, we've got our witness evidence. Now we want some objective evidence that backs everything up, and those are our records. And these cases are often, particularly the bigger they get and the higher value they get, the more forensic they get, and your lawyer will in due course obtain every scrap of paper that ever existed about your child. So all of the medical records, the case management and therapy records, all of the school records, it's all pulled together, it's all reviewed in detail, and when things go to plan, everything backs everything else up. What I think is important to understand here, and always at the outset of a case, is the forensic nature, and things come out in these records because everyone's a human, and we all have things going on in our lives that not necessarily we would prefer to be in a legal case, but nevertheless they come out. Records, medical records, whatever, are disclosable to the other side. They can't be amended or changed, and so once something is in an objective record, it will find its way in most circumstances to the other side. And so it is really worthwhile that if there's something in records that you're concerned about, raise it with your lawyer, because they know that we're all humans and we all have things in our lives, and actually forewarned is being forewarned means that it can be dealt with in witness statements, for example, and it needn't have any impact on the case. And that's me. So I'm going to hand over to Becky.
Thanks very much, Sophie. Great. Okay, I'm going to come on to talk about the different types of compensation when we're looking at how we value the case. So if you win your case, then you'll be entitled to an award of compensation. This is split into 3 different types of compensation, which we refer to as general damages and special damages including past losses and future losses. So looking first at general damages, this is to compensate for the injury itself. It also includes compensation for the pain and suffering and what we call loss of amenity, so the inability to live and enjoy life as before the injury. So inability to partake in sports or recreational activities that were enjoyed beforehand. So how do we work out how much somebody should receive for their injury? It's assessed by the court by looking at other cases, similar cases that have gone before, and seeing what awards were made, and also by reference to something called the Judicial College Guidelines. These provide guidance on the likely level of compensation for all the different types of injury, but obviously each case turns on its own facts. But just to give a couple of examples, if somebody was rendered blind completely, losing vision in both eyes, then the guidelines suggest an award in the region of £250,000. If it's loss of sight in one eye with reduced vision in the other eye, an award might be between around £90,000 and £168,000. For a severe injury such as paraplegia, where the spinal cord has been injured, a bracket is suggested of around 205,000 to 266, and whether you fall at the bottom or on top of that bracket or somewhere in the middle will depend on how you're affected in terms of level of independence, any presence of pain, whether you're suffering depression as well. And just one last example, if you were to badly injure your arms and suffer severe fractures, which left you with a significant residual disability, the award is in the region of 36,000 to 56,000. So as you can see, that they try to categorise by injury, but as I say, each case turns on its own facts. But what is striking is that awards are not high in the UK for the actual injury. Even the most severe and permanent injury would attract an award of only around 380,000 for the injury itself. But in addition to being compensated for the injury, you then entitled to claim for your financial losses, which are broken down between your past losses and future losses. So past losses simply are those financial losses that have been incurred as a consequence of the injury, which otherwise would not have been incurred. It's really important to keep documents, so receipts, invoices, in support of these type of losses. So they could include, for example, travelling expenses, if you're having to travel to hospital appointments or therapy appointments with your child, payments out for physiotherapy on a private basis, occupational therapy, any aids or equipment having to be purchased, wheelchair, trike, specialist footwear, and of course the care being provided by family members. In relation to future losses, these are the losses that will be ongoing after the settlement in the claim and will be incurred in the future. So money is awarded in respect of those. As Sophie's explained, the compensation is intended to try to put the injured person back in the position they would have been but for their injury. Obviously, we appreciate that where the injury is severe and permanent, it's not possible to do this. However, we hope that through the compensation we can achieve that the cost of therapy, equipment, transport, care, all the future needs that the individual requires can be recovered to both maximise the quality of their life and their potential to live as full and independent life as possible. And it's usually the awards for the future losses yet to be incurred that produce the substantial awards that you might have read about in the newspapers running into millions of pounds. So for example, the future loss claim will include claiming an annual amount for the care package that might now be required for the child if they're going to be reliant on carers, purchasing a wheelchair accessible vehicle, future therapies, again physiotherapy, speech and language, and even the additional costs incurred when taking the child on holiday. Okay, so all of this information is drawn together into a document called the Schedule of Loss. So this is all the financial losses that we're seeking to claim are set out in this one document. We only have one opportunity to quantify claims on behalf of the child, so we need to ensure that all the relevant information is included in the schedule. Obviously, with a child, we have to be mindful that they may be at a young age, so it's prudent often to wait until they're a little bit older. I specialise in medical negligence claims, often acting for children who have cerebral palsy. And for instance, even if the family has approached us soon after the birth of the child, we would wait until the child is at least 7 before we would try and consider a final valuation of the claim, because hopefully at that point we will be able to have a final opinion on condition and prognosis and understand the full future needs of the child. So how do we work out future losses? These are expenses that haven't yet been incurred, so how do we know what to claim? Well, they're based on the recommendations of the experts that Sophie's referred to. We'll have a team of experts who will come and assess the child and make their recommendations on what the child will need in future. Often there might be a team of 7 or 8 experts if there's a severe and permanent injury such as cerebral palsy or a spinal cord injury. And those experts will be able to advise within their field of expertise on care needs, accommodation needs, different types of therapies, and so forth. We'll also have a medical expert that we rely on to guide us in terms of the future prognosis for the child. So again, if it's a brain injury, then it would be a paediatric neurologist or a neurologist, and in case of a spinal cord injury, a specialist in spinal rehabilitation. Not only are they predicting long-term prognosis, but as Sophie has already alluded to, unfortunately, they have to go through the exercise of estimating life expectancy. And we appreciate that it can be distressing to have to address these type of issues. But unfortunately, we're required to do so to provide the information to the court to enable the claim to be assessed and to value the level of compensation to be awarded, because we have to say up to what point the compensation has to go and the future losses will be incurred. So how do we set about calculating these future losses? Obviously, the objective is to calculate an amount of money that can be invested today to produce an income that will last for the child's lifetime to meet all of their needs. It is rather complicated how we calculate this, so I shall try and simplify it as best possible. So our starting point is to work out the amount required each year. So for example, if physiotherapy is going to be required, what is the cost of that physiotherapy each year? And we refer to this as the multiplicand. This is then multiplied by a multiplier, which is a number that is taken from some special actuarial tables produced by the government called Ogden tables, and they represent the period of future loss that loss is going to be incurred for. So, for example, the multiplier is the figure which represents the number of years for which the child will suffer the loss, and for example, the number of years they will need care for. It's not, however, based on the actual number of years that the loss will be incurred, because if it would, then the claimant would benefit from receiving the money earlier than needed and would be overcompensated because they have the opportunity to invest the money and earn interest on it. So this is where it becomes complicated and why we have to rely on actuarial tables rather than simply applying the number of years till the end of the child's life. So for example, a child who does require physiotherapy for life, and we're told it's going to cost £20,000 a year by our physiotherapy expert. If a child is now 10 years old, but will live for a further 50 years, then potentially there's 50 years worth of physiotherapy costs that we need to ensure we claim for. And 50 years times 20,000 a year, if you just did that calculation, would come out at a lump sum of £1 million, which if invested and earned interest, you would obviously come out at an annual income of far in excess of the 20,000. So we can't simply do that calculation. Rather, we use the multipliers. They take account, as I say, that the money is being received now to last for life instead of at a future point. And it also takes account of the uncertainties that everybody faces, the risks of redundancy, ill health, or a change in lifestyle over the course of a lifetime. Unfortunately, it becomes even more complicated when we come to look at how we quantify the accommodation needs of a child. The law has been in a state of flux when it comes to calculation of this type of loss. It's not a matter of simply claiming for the capital cost of purchasing a suitable property that's now required, unfortunately. And historically, the formula that was set down by case law that was accepted by the courts led to claimants receiving very modest awards, which was simply inadequate to enable them to purchase the property they needed. And so in reality, what would happen is that they had to dip into the pots of money recovered for other things such as physiotherapy, equipment, and use that money towards the purchase of a property instead. The difficulty arises because if a child, because of their injury, requires a more expensive and larger property than they would have done absent their injury, by awarding a sum to purchase a new property, it would provide a windfall for their estate upon their death. And that's why it becomes quite complicated. So the courts have looked at this, and there was a case that went through the courts right to the Court of Appeal, and a judgment was finally handed down and a decision made last October. It's a case called Swift and Carpenter, and they considered the basis for calculating future accommodation claims. Unfortunately, it's still a little unclear, in terms, especially in the approach that should be taken in cases for children, in particular in relation to any credit that should be given for any property that the child would have had in any event. And there are certainly lots of differing views amongst lawyers interpreting the judgment on the correct approach to take. So each case should be considered on its own facts, and specific advice should be sought rather than just applying the formula that was adopted in that case. In response to the schedule of loss, once that's been sent to the defendant, they then have the opportunity to respond to each of the losses set out, and they produce a document called a counter schedule. They may seek to argue for lower amounts against most heads of loss, if not all. In particular, care is often a contentious issue. For example, on the basis that they may seek to argue that sleeping care only is required rather than waking care, or that one carer is justified rather than two. So we will often ask our clients to keep a sleep diary, and we'll use the witness statements as a good opportunity to demonstrate the real care needs of our client and what happens day to day. Let's move on to the next slide. Great, okay, so settlement. So it can be a long journey to get to this point. And the good news is that the majority of cases do settle out of court and don't have to get anywhere near a courtroom and go to a final trial. Some cases, however, are particularly complex. Often in medical negligence cases, we're ordered to have what we call a split trial. And this means simply that we're going to just concentrate on trying to establish the issue of liability in the first instance, rather than going through the process of looking at all aspects of the claim and trying to work out the value as well. We've got to get over that hurdle, as Sophie's explained, of establishing that there has been negligence and there is liability first. In other cases, we can deal with all the issues in one go, and often, and hopefully, once there's been an admission of liability, we are then just focused on the quantum aspects, on valuing the claim, and so any final assessment by the court will just be on the value of the claim. But usually, as I say, a settlement can be achieved out of court without having to get anywhere near a courtroom. Often the parties will reach a sensible compromise between the figures set out in the schedule and the counter schedule, accepting that there would be risks to both parties to proceeding through to a trial where it's very uncertain what approach a judge might take and whose evidence they may prefer. I think it's also important to note that settlement can occur at any point in the claim. You don't have to go through all of the steps that we're describing today. Offers can be made by either party to settle the claim, as I say, at any stage. And sometimes a settlement will be achieved through mediation or a joint settlement meeting. This is attended by both parties, and it provides an opportunity for the parties to explore the differences between them and the strengths and weaknesses of their case. So these are normally held either at the solicitor's office, so at the office of Irwin Mitchell in our case, or at the barrister's chambers. They're attended by the solicitor and the barrister for each party, together with their respective clients. So what happens at these meetings? They are effectively a roundtable meeting. So often the way it's set up is that there'll be a room for the claimant and their legal team, a room for the defendant and their legal team, and then a third room which we'll have as a breakout room where the parties can come together to make the points they want to in support of their case and put forward offers in settlement. It can take a couple of hours, or it can take the whole day, depending on how the settlement is going and the willingness of the parties to try and reach a compromise. And it's very much a process of offers going back and forth throughout the day until hopefully a compromise that everybody's happy with can be reached. But even if it doesn't settle on the day, negotiations will often continue afterwards. There might be offers made either verbally or in writing following that meeting, which still result in a settlement before trial. So it's not to be assumed that the case will have to go to trial if a settlement hasn't been reached on the day of the meeting. And any offer that is made to settle the case does have to be taken very seriously by the solicitors acting on either side, because if the offer is rejected and then you go on and fail to beat that offer at trial, there are cost consequences, and the claimant could end up having to bear not only their own costs, but those of the defendant from the last date that they could have accepted the offer. So I'm going to talk now a little bit about trial. As I said, it's fairly uncommon, fortunately, but what would happen if you had to go to trial is that everybody's required to attend. So parties on each side, so the child's family would attend, and on the part of the defendant, they will have the key clinicians involved in the case, or if it's a road traffic accident, then the driver would attend. And all the witnesses that are supporting each party will attend, together with all the expert witnesses as well. Each trial is listed for a different period of time, but the more severe the injury, the more experts and witnesses that are involved, the longer the trial will be listed for. So potentially, if you had 7 or 8 experts, you're looking at probably a 10-day trial. And after hearing all the evidence from all the witnesses, all the experts and the client's family, the judge will then ultimately have the decision on how much compensation should be awarded. One further consideration I should just mention when we're talking about settlements and considering compromising and concluding a claim is that the government is entitled to recover any state benefits and NHS treatment charges that have been received by the child throughout the life of the claim. They do this through what's known as the compensation recovery unit, and the underlying principle to this is that it is the wrongdoer that should be paying rather than the state, and so the state should be reimbursed for any state benefits that have been paid out. And there's a maximum period of 5 years from the date of injury that any benefits have to be repaid for. So moving on to the structure of the settlement, we will look at each individual case and consider whether it might be more beneficial for the final compensation award to be received as what's called a lump sum, or whether it's best to receive it as part lump sum and part annual payment, which we refer to as a periodical payment. So some of the losses claimed might be suitable to receive as on an annual payment basis. Most commonly, this happens with the care claim. The care package is likely to be a significant part of the claim, running up into several hundreds of thousands of pounds each year. And to provide security, it's often recommended that that should be received as a periodical payment, so that a payment is received each year on a set date, and the child's family can be reassured and secure that that payment will come every single year for the rest of the child's life, regardless of the estimate on life expectancy that we've had to provide in the case. Whereas the disadvantage of a lump sum, particularly for something as significant as the care package, is that if your client exceeds their life expectancy, because it is only an estimate, there's no guarantees with it at all, of course, then there's a real risk that the compensation will run out, and there will not be enough money to keep funding the care if they've gone on to live longer than expected.
Rebecca, just
Yes.
while you're on that point, are the parents, is the client given the amount on that day, or is it then taken away and then decided? Yeah, no, absolutely. So when the claim is settled, either by way of a judge at a trial or out of court settlement, the parties will then draw up an order setting out the terms of the settlement, and there'll be payment terms, and usually we'll agree 28 days. And so if it's a lump sum basis that's being agreed, then yes, within 28 days, the money will be received into the account. But I'll come on to explain
who the money's paid to. It won't be paid directly to the child or their family. It has to go through another means to protect the child because they don't have capacity and they're not at majority. But the periodical payment it comes on a set date each year. It's normally in December actually. So if the case settled in the January, the annual payment wouldn't be due until the December of that year, and then again in the following December. Does that answer your question?
Yes.
Great. Okay, and so you might be thinking, no, well, how do you make sure that that the annual payment you get is the right payment each year? I mean, the cost of my care is going to go up each year, so surely you can't agree a set amount for the rest of my life. And the answer to that is, again, the advantage of a periodical payment and annual payment is that the payment is linked to an earnings index for carers to make sure it keeps pace with carers' earnings. So it will incrementally increase to make sure that you can afford the care package that's being recommended. Okay, so once the settlement's been agreed, we've worked out the structure of the settlement, the money's being received, or just before the money's being received, it has to be approved by the court because this case is for a child. So what that involves is that the barrister who will have been involved in the case puts forward a written advice setting out and recommending the settlement to the judge. The judge then considers that along with all the other evidence. They'll have a huge bundle of documents which we'll put together, including all the expert reports, all the witness evidence, so they can see everything in the round and come to their own conclusion and satisfy themselves that they consider that this is a reasonable settlement that has been reached to protect the child's interest. And it's at that point where this order that I've just referred to would be made by the court, and it's normally drafted up between the parties and agreed beforehand, but obviously the court has to then approve that order, and that will have the payment terms in, and will specify the 28 days if it's a lump sum payment, and will give the terms of the annual payment to be made if that's been agreed as part of the settlement. And in terms of the annual payment, the only thing that the defendant will require each year is proof of life. This normally comes from the GP just to confirm that the claimant, that the child, or who then may be an adult, is still alive and entitled to receive that annual payment. The approval takes place at a hearing at court, so that may be the only time you do actually get to go to court. In terms of who attends, again, it's the legal team for both parties, so the solicitor and barrister representing each side, and also the client's family come along. Sometimes the judge will say a few words at the end to acknowledge the care that the parents have provided to the child, and the importance, and recognise the importance of the settlement for the family, for moving on and providing for the child for the rest of their life. And sometimes, and in fact often in the case of children, and what's called an anonymity order is made by the court, and this means that the identity and interests of the child are protected by anonymising their details on all the court documents. Okay, so I'll move on to my next slide. Okay, so protection of funds. So I want to talk now a little bit about the mechanisms we can consider for where the money is paid once it's been agreed. So because we're acting on behalf of children, we've obviously got to be very careful here, and their interests need to be protected. If it's a child who is likely to lack mental capacity by the time they reach 18, then usually what's called a deputy would be appointed by the Court of Protection to manage the award of compensation. The Court of Protection effectively helps people who don't have mental capacity to manage their own affairs. It has the power to make decisions for people about their money, their property, health or welfare. And if the court gives these powers to someone else, then that person is called a deputy. Although it is possible for a relative or a close family member to be appointed as a lay deputy, where a large sum of compensation has been awarded, it is recommended really that a professional deputy should be appointed. For example, we have partners at Irwin Mitchell specialising in court of protection issues who are able to be appointed as deputies. because it is very onerous being a deputy and managing the funds and reporting back to the Court of Protection. And we would then seek to claim back the fees of the professional deputy as part of the claim. The deputy doesn't have to necessarily be appointed at the end of the claim. They're often appointed during the life of the claim because, as Sophie mentioned, we would hopefully get an admission of liability at an earlier stage and then seek what's called an interim payment, so a payment on account of the final damages to enable rehabilitation to be put in place or equipment to be purchased and so forth. And obviously those funds again need to be managed by a deputy, so the deputy would have to be appointed at an earlier stage. Alternatively, we might consider a personal injury trust. This is for a child who is likely to have capacity at the age of 18. It's a much more straightforward process. A trust deed is drawn up, a trust bank account is open to make sure the funds are kept completely separately from any other funds. But because it's for a child, again, it has to be approved by the court. And the benefit is that on turning 18, either the trust can be wound up completely and the money goes across to the child into their own account, or they can continue on with the trust, particularly if they're going to be in receipt of means tested benefits, because effectively it can be used as a vehicle to ring fence those benefits and ensure that they're not the compensation isn't taken into account when assessing eligibility for means tested benefits. And the third and final option that we might have to think about when we come to look at how the funds should be administered is what we call the Court Funds Office. Again, this is if a child is likely to have capacity, mental capacity at 18, but no personal injury trust has been set up. Instead, the funds would then be paid into the Court Funds Office and held there until the child turns 18, at which point the money can then be paid out to the child. It can be quite difficult to get payments out before the child is 18. You are entitled to ask for payments if you can evidence what they're for and provide documents in support, for example, if you wanted to buy a computer for the child, but it can be a bit of a difficult process sometimes to get that money. Okay, moving on. Okay, so I just wanted to say a little bit about our services at Irwin Mitchell. We're a large national firm with offices across into every corner of the country, getting bigger by the day, certainly grown exponentially since I joined around 14 years ago. We are a full service law firm, and we do have a keen eye to understand and support all of our clients' needs as they go through the process of bringing a claim, trying to identify any other legal advice that they may require. We have various ancillary services that might be needed as part of the claim. I've already discussed the Court of Protection and the necessity for a deputy or personal injury trust. We have a family law team. Sadly, there may be family relationship breakdowns during the process of the stress of bringing a claim, but we have colleagues who can advise. Education law, we've got specialists in this area. They can often be brought in if we need to challenge the education and health and care plan or any local authority provision. Similarly, our public law department can challenge any cuts to health and social care. And we have wills and probate and conveyancing. And we also have a team of financial planners called Irwin Mitchell Asset Management. And again, where there's a large sum of compensation arising from a life-changing injury, they can offer financial planning and investment advice to ensure that that money will last for the duration of the child's life. They also have a great service where they offer a free financial health check during the life of the claim to parents as well. Okay, and moving on to my last slide. I act for a delightful young lady who suffered a spinal cord injury following surgery to correct a scoliosis in her spine. She was only 12 years old at the time. We've reached agreement with the defendant on the liability issues around a year ago, just around the beginning of the pandemic. It was compromised on the basis that she will receive 75% of the award of compensation that is finally awarded. We compromised on this basis as there were difficult issues on both sides, and there were risks on proceeding to a trial on the liability issues, and you know, there was a risk of losing, and so often claims can be compromised to reflect that, what we call litigation risk. Since settling the liability issue, we've gone on to start valuing the claim, gathering evidence from experts, witness statements. We've secured a significant interim payment, which has enabled the family to purchase a wheelchair accessible vehicle. We've appointed a case manager to support the family and coordinate therapies, and put a buddy in place, and help to source various pieces of equipment. The claim is ongoing, and we're continuing to obtain evidence to support the quantum, the value of the case, allowing for all of her future care needs, accommodation needs, equipment, therapy, etc. But what's really struck me is my client's resilience and determination following her injury has just been remarkable. Along with her family, she's got incredibly supportive and dedicated parents, and it's my pleasure to introduce her father today, who joins us to provide his insight into a parent's perspective of pursuing a claim. Thank you.
Tom, sorry to interrupt. You're just on mute, so we can only see your lips move and we can't hear anything.
Apologies for that.
We'll let you away with it.
Thank you, Rebecca. So I think what I'm hoping I'm able to offer today really is an insight for being a family which you know, we were very, you know, our lives changed really when our daughter had the operation, and there was obviously some complications with that, and I think we were quite lucky in we were recommended as Irwin Mitchell by a professional who was working in our daughter's rehabilitation provision. So I think, you know, really quickly we were able to develop our relationship very quickly and try to understand the kind of what happens next bit, really, because you're kind of stuck in a place of shock and horror, but you've also got to be very pragmatic very quickly, and that's you know, it's quite a tough time, and I think it was just so important for us to have some of that taken away really by our initial introduction to our solicitor, and they kind of framed out what they could do to explore the possibility of a claim, the kind of time scales, what would need to happen next. And I think it's really evident that we felt held right from the beginning, and I think it's okay to say, you know, there's lots of solicitors firms that you could approach. They are emblazoned across the TV and everywhere we go. It's, you know, you kind of see the ads: if you've been injured, ring this number. And I think, you know, we never felt that we were getting anything except for really good advice, honesty, transparency, and it was, we immediately felt like we were being listened to. We were being understood in our concerns and our questions, and we felt supported, and I think it's gone on from that really. It's that really, you know, the massive value of building your relationships at that stage. It's important to have open discussions, ask questions, and you know, there's a lot of information out there which is misleading, and I think it was I'm not sure if it was Sophie said at the beginning about you see these massive sums of money sort of thrown around in the press and in the media, and it's quite, there's a lot of misinformation out there, and I think, you know, to get the real the kind of lowdown really, and the real good clear explanation of what happens is really important. And you know, we did we did a lot of research. I say we did a lot of research. We looked at things we thought were important. So we did look at cases. We looked at other cases. We looked at and they're quite easy to find if you Google accordingly. But it does give you a bit of an idea of what the steps that happens next. And with your, the advice from your solicitor, they will point you to look at relevant cases or relevant documents or terminologies which are helpful. I think fundamentally for us, we right from day one, when we knew things weren't going the way we hoped in hospital, we started keeping a chronology of people we spoke to, what was said, what decisions were made, names of people involved in decision making, and I think that really helped us be quite prepared for the next few years, and certainly a big piece of advice for me would be to keep a record, get advice on setting up files. We have many files at home with paperwork in, and also electronic files. It's really helpful to have a separate email address than you normally use, because there is an abundance of backwards and forwards communication. So I think you just need to prepare yourself for that and if you're organised in amongst the chaos, it does give you a kind of a helping hand. Cover next slide, please.
Absolutely.
Thank you. So yeah, perception versus reality. I guess I kind of touched on this a little bit. Terminology. Well, I've learned new words that I'd never heard of before, and certainly interestingly that we talked about liability quantum and schedule of loss, etc., things I'd never had any idea of before going into this process. But again, I think it's just having those things explained to you as you go through start to make sense. And along the timescales, we knew that our situation was extremely complex, and we learned as we went on that the medical world is full of different opinions, and different experts will have different views and different angles, and we were always aware that it would take some time. And I think you have to appreciate, unless you're from a medical world, it was inspiring, the information from people that all manner of professionals brought to the table, really, but they were key. It wasn't just a case, and we naively thought, well, we think the surgeon's done something wrong, and so therefore we'll have an expert from a surgeon who will probably say it, and their perspective and our perspective. It's not just it's incredible the amount of professionals that have to be pulled into these discussions, and I think Rebecca mentioned probably eight experts. I'm not sure how many we've had, Rebecca, but I think it's probably more, it feels like more than 8, but they all bring something really viable to the table, and it's really important. And we've learned an awful lot around not just the kind of the medical framework, but the legal framework as well. Sorry, can you go back one? It's just jumped on a.
Oh, I'm sorry,
that's okay.
Tom. Sorry,
no, that's okay. It's the legal, the legal framework, the medical framework. They're things that, unless you work in those areas, will be completely alien to you. And I think it's absolutely key to open up really strong lines of communication with your solicitors, and don't be afraid to ask questions. Don't be afraid to ring. Don't be afraid to email. And if you're not sure, you have to ask. And we went through some quite significant highs and lows, really, I suppose, as we still do in some ways. But I think our mantra has always been to think of three things, really. Things you can control, which is great, because you can make your point known. You can provide evidence. You can provide a statement. the things you can influence, where you can add value by your own thoughts or your own kind of opinions, and the things you got to accept, and there's quite a lot of them, and certainly in terms of the timescales, in terms of the framework, you know, try not to beat yourself up about it, because you're not going to change them. Some of the laws that I know that Rebecca at times probably thinks, oh crikey, he's asking a question here, and I think, well, you know, I just don't know what it means. And it's really important to understand that you've got you've got to accept some things which are hard. Court timescales, court processes, I'm not going to tell you to change them, so I just need to let them go, and you've got to try and box things away and compartmentalize things as best you can. But certainly the things you can control and the things you can influence, you know, it's really important you're an active part. It isn't just a case of you provide your solicitors information and they get on with it. It's not like that. It's really interactive. It's really you're a massive part of making things work quickly, and also fundamentally it's you know, it's your story, it's your life that is affected. So you have to, don't be afraid to ask the questions, and don't be afraid to have the discussions.
Gosh, Tom, can I just say, and it's more of an observation really, it's just, and everybody's been listening today, it's so incredibly clinical and complex, but right in the middle of all this is this huge emotion, and it's people. When it's either your child or your brother or your sister or your partner, it's huge, isn't it?
It is, yeah. And I think you have to all these things are and I'll be quite honest, it feels like when it first happens, it feels like your world has stopped, but the whole world, everybody else's world is carrying on as normal, and that's quite difficult. But I think it's knowing that you're not in it on your own, and the emotional part, you deal with that. You know, we dealt with that with our family, and we've got, you know, really strong family bond, and you know, our daughter was fantastic all the way through. They didn't really understand what was happening, and we said neither did we really, but so we kind of all owned it together. But yeah, it's difficult to balance the here and now and the future, but you find your own way. I just think having supportive people around you is key. So yeah, that's what I add to that one.
That's inspirational.
Next slide.
There you go.
Expert witnesses. Well, I guess I kind of touched on this a bit already. Expect to say the same thing over and over again to lots of different people, and because they don't know your story, and they have to, you know, I kind of touched on it earlier on, they have to know every single thing. They cannot afford to get things wrong, because it can massively impact on the case. So you do have to, you know, and a lot of questions, a lot of information, a lot of repetition, but you just got to stick with it really. And again, I think, you know, just touched on a bit earlier about keeping records, keep technologies, don't throw anything away, try and file things in a way which makes sense in you know, in date and time order. But also don't be afraid to ask questions. And I've certainly sat in many a case conference with the experts and say, I don't know what you're talking about. Can we go back a step? Because I don't understand what you're saying. I don't understand what you're suggesting. That's actually made me feel quite anxious. That's really actually quite good. Can I just clarify that that's what you're saying, that's what you mean? And I think it's really important. They are really, you know, the experts are in your corner, and they are, you know, they can only write a report based on what you tell them, and it's really important. Don't be afraid to not agree with things. And I've had, you know, several things where I've said, we looked at a statement and said, well, that's not accurate, that's not how we remember it, this is how it happened. And that's fine. And I think, you know, don't ever be afraid to just say, well, you know, challenging accuracies, you know, put a red line through things and send it back to Rebecca. She likes that sort of thing. Send it back. So yeah, it's you know, don't be afraid. You're part of you're real part of it sounds a bit weird, but you're part of a legal team. You're not, but you are. That's what it feels like. So yeah, that's you know, expert witnesses, they're great, and they do sometimes talk in language you think, I don't know what you're talking about, but ask. Don't be afraid to ask. And I think this final slide. Yeah. So as Rebecca said, we're now in the process of liability was settled just March April last year, and I suppose we're in that kind of place now where, having gone through the joint settlement round the table situation, if like, although that was all virtual, which was quite strange, it just really hits home the complexities of the legal process, and I think we've kind of got kind of semi-closure now. I think there was always we always knew, and we were certainly informed by Rebecca and her team and the barristers, that it was a very difficult case to prove, purely because of medical complexities. And so when we got to the point of liability, and we were able to secure the 75% liability, we were really pleased with that. And you kind of feel like that's brilliant, because you got kind of semi-closure, although you haven't quite got it, because you still think, well, actually, it feels like you've proved that someone else did this, or someone else was responsible for it. So you get the closure, but it still makes you quite cross. You feel validated, but it's still frustrating, because at the end of it could have been avoided, but you have to move on and try to think about securing stability and securing what you need for the rest of your family members' life. So it's okay to be emotional, and I think don't ever lose that fact that it will be a bit of a roller coaster all the way through, but it's a journey.
Yeah. Tom, can I ask how many years then, at which point you're at now, and how long has that been?
So the medical procedure was 2012 or 13, I forget, 2013, and we've just been able to, a year ago. But I have to say, there's been so many different roads it goes down in that time. And I was thinking 2 or 3 years maximum, this will probably be all done and dusted. And I could understand now why it wasn't.
Yeah.
But I never felt like I was being sort of just not being. I never felt that I'm not being listened to. I never felt that I've been kind of, well, actually we don't know yet, contact us again in 6 months. Nothing like that. The amount of communication is just been non-stop. And it's really appreciated that that's what Irwin Mitchell have been able to provide to us. But that certainly feel of really in it with us,
not for the long ride,
not just
for
a
the
client.
long term.
Yeah, absolutely. Yeah,
that's very important, isn't it? You
It's
start on a very huge journey, and you do not know what comes next, I'm sure, in some weeks.
No.
And to have these many, like you say, many different people around the table with you to, well, nowadays it's virtually holding your hand, but they're there from the beginning to the end. I think you might have one more slide, actually, Tom.
We do, just about case management, Tom. I don't want to touch base a wee bit on it.
Yeah, so basically, we secured an interim payment, which was Rebecca and her team secured the interim payment, which is fantastic, and we were able to make a purchase of a wheelchair-assisted vehicle, which was an absolute game changer for us. And also put in some physio support, which was great, and that continues to be really good. And the case manager who was appointed, we were included in that process of recruiting the case manager, and she's been such a big difference, because they come from generally the medical kind of world, if you like.
Yeah.
Really well versed in our case, spinal cord injury and rehabilitation. So they know people, they know resources, they know services, they know how to open. It sounds a bit like Dragon's Den, but they kind of know how to open the doors that I would never be able to open. And I think again, it's very much having that open, transparent and engaging relationship with your case manager. Don't leave them to it. pester them a little bit, although with ours we really don't need to, because she doesn't knock on doors. She feels like she bangs down doors, which is fantastic. And there's not, I'm in contact with my case manager at least 3 times a week about something. And again, it's like she feels almost part of the family. It sounds a bit weird, but certainly, we spend a lot of time talking to her about all manner of things, and they spin a lot of plates, but
yeah,
they spin them really, really well.
Yeah.
I
think Snap feel the same about case managers. They wear lots of different hats.
Yeah, 100%.
Yeah.
That's brilliant. Thank you so much.
Oh, thank you so much.
No problem at all.
Really, thank you. Thank you, Janet. Well, guys, I just want to say again, thank you very much to Rebecca and Sophie and Tom. We've really enjoyed that. The recording will be up on the website if anybody wants to refer back to, for any further information. There was loads of information there, guys, really thorough. So thank you so much. Thank you all very, very much, and have a great day. Take care.
Thank you, guys, and thank you, everybody.
Bye. Bye-bye.
Bye, guys.
Thanks. Bye-bye.